Hello and welcome to my channel. I'm Leanne Newton and today I'm going to recap what has once again turned out to be an eventful week in the Wayfarer and Blake Lively multiverse of lawsuits. You can check out my threads on X, which were written in real time. My username is KiaraJ2001. I am not a US attorney. I am qualified in UK law. Everything I say is my personal opinion as someone who understands and interprets the law. It is not intended to be legal advice. I would appreciate it if you could please like this video and subscribe to my channel. You can also press the notification bell to be alerted to future content. A lot of things happened last week, so much so that I will split my weekly recap video into two separate videos. This will be part 1, and I'm aiming to get part 2 out either tomorrow or Thursday, depending on how this week's filings go. So, Blake Lively's request for an extension to respond to Jed Wallace's amended complaint was granted. That response is now due this Friday. Marvel added a new lawyer to the docket. Exhibit A of Leslie Sloane's motion to compel was unsealed. There was media misrepresentation from the Lively camp. And Stephanie Jones filed motions to dismiss against Abel and Wayfarer. Now, as I've said before, there was a lot more that happened, but I will cover that in a separate video. So Marvel added a new lawyer to the docket. Adam Levin joins Jacob Albertson from the law firm Mitchell, Silverberg and Knupp, LLP. He is a top entertainment lawyer who has previously represented entities such as Warner Bros. And Touchstone Entertainment. This addition may or may not be signaling something happening imminently, maybe a filing or a hearing. I will keep an eye out on the situation and update as soon as I know more. Leslie Sloane's Exhibit A was unsealed. There turned out to be nothing of great interest here, but I will make a brief comment on the objections and definitions. There are general objections to the interrogatories as being to, and then they insert every known possible objection. Using all of these objections is completely normal, and Wayfarer must lodge them for two important reasons. Firstly, if they can limit or exclude anything before trial, that's the best outcome for them. And then secondly, even if the objections are overruled, there needs to be a record of them being lodged for any possible future appeals. Now, all parties will be doing the same thing. They will all be doing this. It doesn't mean anything or suggest anyone is trying to hide anything. Just ensure that information and evidence are treated correctly and anything improper is rightly excluded. So, the other thing I noticed was when Sloane said that Wayfarer had waived its local civil rule 33.3a objection, she wasn't being entirely honest. So there may have been a requirement to specifically object to each interrogatory request that the party is seeking to rely upon Rule 33.3a. But here, where I've highlighted, this objection is included in the general objections too. Wayfarer has taken some issue with the broadness of Sloane's definitions, particularly the definitions of agent, employee, and you. With the first two definitions, Wayfarer is suggesting that they are not well defined enough and could be treated so broadly as to include attorneys. Wayfarer confirms that they intend to interpret the definitions as only referring to the specific individuals referred to in the requests. With the definition of you, Wayfarer has confirmed to Sloane that they intend to interpret that to mean Baldoni. Other than that, there wasn't a great deal to discuss in the interrogatories. Then we had Stephanie Jones's motion to dismiss against Jennifer Abel. So I'm going to briefly cover this, along with she also filed a motion to dismiss against Wayfarer. There are separate threads on X, but essentially Jones is making the same mischaracterizing comments about what Abel or Wayfarer are alleged to have admitted. So, for instance, Jones claims that Abel now admits that there was a lawful subpoena, but the counterclaims were clear that they believed that the subpoena to be anything but lawful. Jones admits that she could read Abel's messages, but argues that there are no facts that have been alleged that supports the claim that she actually did read the messages. Now, that is going to be an issue for the finder of fact, which is essentially the jury, and I think Judge Lyman won't be able to dismiss her, as Abel has alleged that Jones did access her messages. Jones has denied doing this, but has admitted that she could have accessed them. Abel will respond by saying that discovery will be required to gather more information about this. To cover herself over the sharing of the text, and seemingly in the case the subpoena isn't as legal as she's claiming, Jones does cite the Speak Out Act. So I didn't like that. I feel like there's another person in this lawsuit who's leveraging a law designed to help victims of genuine abuse, harassment, and retaliation, and they're using that law for their own gain. Personally, I feel Jones knows fine well that there was no smear campaign, because she confirms herself in her claim against Wayfarer that she was at a lot of meetings, copied in on the majority of the communications regarding the PR strategy for Wayfarer and Baldoni. She was the CEO of the PR company handling this crisis. So if there was a smear campaign, and I don't believe that there was one, then Jones was every bit as implicated as someone who acted as Wayfarer's agent and vicariously as Abel's employer. I do feel Jones is being a bit selective with the facts. Jones then tries to suggest that Abel hasn't proven that Jones' work never intended to make good on their promise to release Abel's personal number back to her. And this is where I get quite frustrated. I read the text messages between Abel and the Chief of Staff, where initially Abel was promised that her number would be released the same day. And Jennifer Abel sat in a phone shop for 4 hours waiting, trying to make contact to request this transfer and being promised, yes, yeah, we'll send it soon. I also saw the evidence that was submitted that the Chief of Staff stopped communicating. And then there's one rather obvious final piece of the puzzle, and that is that Jones' work never did, and still have not, transferred Abel's number back to her, and have offered no acceptable reason for failing to do so. That is fairly conclusive evidence to support the claim that Jones' work never intended to transfer Abel's number back to her. "You haven't promised, I had no intention to make good on my promise," is such a disingenuous argument to make. She didn't make good on it. She still hasn't made good on it. And she's arguing in the pleadings that there was no obligation on her to make good on it. The lack of intention has been pretty well proven by Stephanie Jones herself. So now we have a motion to dismiss against Wayfarer. The big standout in this filing for me was the sheer aggressive tone that Jones used when talking about Baldoni and how hard she is litigating the SH claims. Now, I know that Jones has to do this because without the SH and retaliation, She doesn't really have a leg to stand on. Still talking about the subpoena, Jones now falsely suggests that Wayfarer made no serious attempt to suggest that Jones acted improperly in responding to the subpoena. We're obviously talking here about the Van Zandt lawsuit subpoena. But firstly, I recall them strongly suggesting that the entire subpoena was improper and that Jones was part of the collusion to obtain it. Secondly, they're not going to make any argument that she acted improperly without further discovery, including a copy of the subpoena. Wayfarer needs to know the extent of the collusion for the Van Zandt lawsuit and subpoena because Jones has to respond to a subpoena if served with one, or she could be found in contempt of court. Wayfarer has criticised her for not notifying them or for not attempting to challenge it, as Marvel has recently done to Wayfarer. But Jones can't ignore the subpoena, and Wayfarer needs more information to understand her knowledge of the subpoena's impropriety. Of course, Jones refers to the Speak Out Act as a Plan B, just in case the subpoena is improper. Jones claims that Wayfarer have not alleged whether her statement that they had orchestrated a malicious smear campaign was true, false, or published with actual malice. Now, at this point, I'm seriously questioning whether Jones is even responding to the correct document, because they did categorically state it was false and they pleaded actual malice. She then tried to plead that her statement is a constitutionally protected opinion. Jones cites reasons why she believes there was a smear campaign, which are just ridiculous. She cites the premiere, where the media was reporting tension between Baldoni and Lively, and of course they were. Lively segregated him from his own movie premiere under the threat of not approving rights to her image or likeness. She made Baldoni go to the basement. The media, like a lot of people, was questioning why Baldoni wasn't with the rest of the cast. Jones should have also been questioning this if she'd been doing her job. This is clearly a PR crisis that required PR crisis services. I'm not sure that Jones is making the strong argument she thinks she is here. I did find one thing where I felt maybe Jones might have slipped up a little bit. And I'm not claiming it will mean anything, but I do wonder how Stephanie Jones was able to figure out that a subpoena related to a company called Van Zandt Inc. could potentially relate to Wayfarer, given that, from what we know of it, that is a rhetorical question. I already know the answer to that. In the same way that I'm curious as to how the subpoena knew to look for a mobile phone, I find this comment from Stephanie Jones highly specific. I would be interested to know how quickly the response was and how many phones were searched, because Jones Works owns a lot of phones. So I've seen news articles flying around from Blake Lively's lawyers talking about her willingness to testify as if she's making some big heroic sacrifice on behalf of sexual harassment victims. I just want to clear this up because it's bullshit and nothing more than a PR spin. Lively doesn't have any choice but to testify. Even if she decides not to testify for her own claims, she'll struggle to win if she doesn't. But also, Wayfarer and Jed Wallace have claims against her. They can and will subpoena her to testify, and if she refuses, she could be found in contempt of court. Her suggestion that there is anything remotely voluntary about her having to testify is ridiculous bravado, given that she once tried to get herself out of facing Brian Friedman in a deposition. This display of gutsiness is interesting. So I'm going to end this part here, as it was at this point I ended up being a birth partner and the docket alerts went off like a pinball machine. So I'm going to continue all the various filings, the various motions that came in on a second video, which, as I said earlier, I am hoping to get it released either today or tomorrow. Sorry, not today or tomorrow, tomorrow or Thursday. But for now, thank you for watching. Don't forget to check out part 2 and have a great evening. Thank you.